90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is Attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we're going to discuss what to do after an accident, especially if you're injured in the accident. My special guest is Attorney Ira S. Slavit, and he's the immediate past chair of the Nassau County Bar Association Plaintiffs' Personal Injury Committee, and his firm has offices in Mineola and New York City. Ira, welcome to Law You Should Know.
Thank you.
I know you've been handling accident cases for many years. What are some of the common situations that you help people after an accident?
Our office handles many different types of personal injury cases. Just broadly speaking, we handle motor vehicle accidents, whether it's someone driving, a passenger, or a pedestrian. We handle premises liability, which more commonly is known as slip and fall or trip and fall, whether it's a private landowner or a municipality. We'll also handle construction site accidents if a construction worker is injured on the site, and we also handle medical malpractice cases.
And what are some things that someone should do or not do after an accident?
Nowadays with cell phones, I think the most important thing to do is take photographs. If you've slipped on ice or some kind of condition, take photographs because you want to preserve that, especially if it's snow or ice, because that could change very quickly. But also, very importantly, don't just take close-ups of the specific condition. It's also very important to take pictures from far off to show where in relation to other things.
To show other landmarks.
Yes, otherwise if you're just looking at a crack in a sidewalk or a hole, you won't know where it is.
Exactly right. So you want an address or identifiable building or some landmark so that people can understand exactly where that crack was.
If you can take a picture that shows the condition plus an address on a building or street signs are very good to show exactly where it is.
And of course, after a car accident, pictures can be important too before the vehicles get moved.
Yes, in fact, if you drive now in the city, they say if it's a minor accident with no damage, move the vehicles, which isn't such a terrible idea, except you really should now take pictures before the vehicles are moved, because otherwise you're very likely, or it's possible, someone's story might change.
And people may not be aware of where it is, and stories could change. And again, you want to put landmarks in those pictures too. Some close-up, some showing the debris, the points of contact, and some showing a landmark so people know exactly where it was on the roadway.
That's right.
What are some things a person should not do after an accident?
Well, if you are, say, in an auto accident and the driver, people from another vehicle have conversation with you, don't admit liability. Don't even really apologize. You can express concern, hope that nobody is injured, but don't admit that it was your fault. And that's at the scene. Then there are other things very important not to do after the accident, after you get home. We could talk about those if you like.
Oh, yeah, and I just want to go back to the scene. And if someone, might leave the scene of the accident, you never know. But you want to make sure you get pictures of the plate number of the other vehicles, all the vehicles involved, and maybe even the registration sticker, just to identify the vehicles.
That's 100% correct. I think gone are the days where you look at someone's registration and you write the information down. Take photographs of the registration, the license, and if you can be seen shown the insurance card, take a photograph of that also.
And if people have pre-existing damage, let's say on the other part of the vehicle, you may want to take a picture of that just to show what damage came from this accident.
It's always a good idea when you're taking pictures, even of just your own vehicle, to take all four sides of the vehicle, not just the side or sides that were damaged in the accident.
And again, landmarks and showing the position of the vehicles with respect to each other and where they are on the roadway, because that will shortly change. And people may have different views or ideas on what happened.
Yes, or as you mentioned a little bit earlier, maybe your recollection is not so great because of the trauma and the adrenaline flowing.
And if there's something affecting the travel, another broken down car, a double parker, whatever it is, you may want to, that could change. So you may want to take a picture of that too.
Construction sites also, or construction work on the road could end up being very important.
Anything else that a person, and again, it's not good to argue with people, and it's a good idea to call the police if there's a car accident, or make sure you have the information.
It's better to have a police report. Insurance companies like police reports. And one of the things you have to keep in mind, it helps us as we're representing injured people, is to think about what the insurance company likes to have in its file, because that will help possibly resolve the case. So maybe there's no question that the accident actually happened at the location and involved their insured.
And be very clear on what you did and what you believe the other person did or did not do to the police officer. And if there's a witness, if for some reason the police officer doesn't want to take down that info, or the witness doesn't want to wait, you want to try to get that witness's contact information.
You've really hit a great point here, because so many times clients will tell me, if I asked, were there any witnesses? Oh, yes, there were witnesses. Well, what were their names? I don't know. Well, then they're not witnesses. It doesn't count. It's hard to sometimes think of it in the heat of the moment, but if you know a witness, get a name, get a cell phone number, an email address.
And that's true with slip and falls too, or even a construction accident, because sometimes there are disagreements about what happened, or maybe you're not aware of everything. That witness can make a big difference in showing the course of events.
You can avoid a he said, she said situation if there's an independent witness.
Any other suggestions on what to do or not do after an accident? Obviously, if someone needs medical help, try to prevent other cars from, hitting a vehicle or the people. And if someone needs medical help, call the authorities.
Generally speaking, whether a police officer, especially, or a medical ambulance EMT speaking to you, it's probably better. You don't necessarily have to go into details as to how the accident happened, but you definitely want to be thorough and specific as to what parts of the body are hurting you, so that it gets documented. A lot of what insurance companies look for is documentation of injuries and then treatment.
Let's fast forward. The people have left the scene of the accident. I guess if it's people should report the accident to your insurance company, even if they're not at fault.
You definitely should report it to your insurance company, but if you know you're going to be contacting a lawyer soon, within a matter of a day or so, better to contact the attorney first, because the attorney can report it for you to your insurance company and maybe prevent. A lot of what people don't realize is they say something that to an insurance company that seems innocuous, and then they've created a problem.
This is a trained questioner on the other side looking to lock you in or limit the story or whatever it is. The lawyer is going to advocate for you. So as you said, if you get in touch with the lawyer can report it for you.
And that applies both to your own insurance company and the other insurance company.
And if it's a construction accident, you want to make sure there's a record of it being reported. If it's a slip and fall case, if it's in a store or something, you want to make sure it's reported to them.
Yes, you do. And sometimes it's not a bad idea, if it is in a store, to maybe see if someone who works there will tell you if they have cameras that show the area where you fell. Because it can be very helpful to have
And as
that.
you said before, take pictures of it, what that aisle looked like, close-ups, and also to show landmarks, exactly where it was, because things can quickly change, be cleaned up or moved.
And actually, some department stores, as a matter of policy, change their displays very frequently because they think it helps boost sales.
And even outside premises accidents, things can change very quickly. A pothole could be filled in, whatever it is, you want to take a picture of it.
Absolutely.
And snow and ice or whatever else. What are some other things to remember? It's important to contact a lawyer about like yourself, who represents plaintiffs, to see what your rights may be and what are the next steps?
I think you need to do that because you just don't know. You won't know. And if a lawyer doesn't think you have a case, then nothing lost, nothing ventured, nothing lost. But you may not realize that there's a case, or you may not realize that there's a party responsible for your accident. One other thing very important, this is a big do not give recorded statements to anybody, even your own insurance company. Never, ever, ever.
Don't do it alone. Have your attorney with you if you're giving any type of statement.
Yes.
You have to sign anything or whatever kind of statement is. You represented by an attorney. You don't want to give it to anyone else, no matter what they say. Have them contact your attorney so your rights can be protected and you won't be manipulated in any way.
Exactly. If you're contacted by someone from an insurance company or an investigator, all you really have to say is, I've hired an attorney, here's the information, call them, or I'm considering hiring an attorney. But even your own insurance company, where it's still your insurance company, no recorded statement without a lawyer being present.
Right. So you're cooperating with them, but you don't want everything done through your lawyer. Otherwise, it can come back to haunt you. And even if a police officer wants to interview you for something, you can still have a lawyer present, whatever's going on.
The issue isn't really that we think people aren't going to tell the truth. The issue is people say things and they use words that then somebody else tries to turn and twist and give it a whole different meaning.
And someone puts words into their mouth. So things can be manipulated. You want to have, obviously you got to give your information and the bare bones maybe to an officer at the scene, but otherwise you want to have your lawyer available with you.
Yes, and you also need to speak to a lawyer because you need to know what time limitations may be involved. And that can be in a few situations. In a car accident, as you know, there's a no-fault. Insurance will pay your doctor's bills and lost earnings, but you have to submit the no-fault application within 30 days of the date of accident.
And there might be other applications for workers' comp or other benefits or insurance coverage, and the lawyer will, help you meet all those deadlines, or for notifying municipality or of a claim or things along that line.
Well, municipalities is a very important. I'm glad you brought that up because generally people will say, and it's true, that the statute of limitations for negligence cases in New York State is 3 years. But if it's a municipality, it's a whole different ball game. It's a 90-day usually time limit to serve a notice of claim. And sometimes people may not realize that a municipality needs to be served with the notice of claim.
And the lawyer needs time to conduct an investigation to see who the responsible parties may be, and that takes a little time. I just want to remind our listeners, we're talking about what to do if you have an accident, and we're talking with Ira S. Slavit, and he's a partner in the firm of Levine and Slavit, and they have offices in New York City and Mineola. And Ira Slavit is also my guest, is also the immediate past chair of the Nassau County Bar Association Plaintiffs' Personal Injury Committee. And you've been telling us about the different types of accidents, what can be important things, what information to record at the scene. And this is true whoever you are, even if you're not necessarily injured, you want to identify all the information, the vehicles, what happened, just so it's preserved, so it's there in case that information is needed, down the road.
Many clients at a scene of accident with the adrenaline flowing don't realize that they're injured. And then if it's the next day and they realize they're feeling worse, and they haven't done all those things you just mentioned, you can't go back and recreate it.
And scenes change, detail change, witnesses can't be located, people's perceptions change. And so that's why you want to preserve what happened through pictures and through whatever other information you can gather. Eventually, Ira, if someone is injured and you or another personal injury lawyer are going to start a lawsuit, what are some of the steps that go on in the beginning, initiating a lawsuit?
Lawsuits in New York State are commenced or started by filing a summons, usually with a complaint in the court. Unless it's a municipality, then you have to first do the notice, serve the notice of claim. But the lawsuit is really, the papers are kind of a bare bones allegations as to what the claim is about, and it's just really to engage the other side, let the insurance company for the other side know they've got to get a lawyer involved in the case. They'll serve a response to your papers, which also doesn't really say very much. And then the case will move into the discovery phase where there's papers that get exchanged, medical reports have to be exchanged, photographs.
And we'll talk about that more in a second. I just want to mention that, if you could be the plaintiff, the person injured, or maybe another party in an accident, if you are served with legal papers, you should pass them on to your lawyer if you have a lawyer representing you in the case, and they'll pass them on to the proper person. Or if you have insurance, if you're being sued, you want to send it to your insurance company so that they can take the proper steps to make sure you're covered and timely and properly represented. And if you get letters or correspondence in the mail, let's say you're a plaintiff or someone else who was involved in an accident, don't ignore it, but send it on to your insurance company or give it to your lawyer.
If you have a lawyer, usually that's where I would start.
If you have a lawyer, give it to your lawyer. But if you think you're being sued or a claim is being made against you, don't ignore it. Pass it to your insurance broker or your insurance carrier.
Well, you could jeopardize your coverage if you haven't timely reported it.
Or if you don't forward information about a lawsuit. So a lawsuit is started. What are some of the things that go on? Let's say the exchange of information, or what would you want your clients to know very simply about the legal proceedings that you will help guide them through and prepare them?
Actually, I want to just backtrack for 1 second,
yes.
if that's all right, and mention something else that's very important. That's social media, because nowadays the courts will allow a lot of discovery of your social media. We advise clients that if you've already posted something, you cannot take it down. But don't post anything. I mean, my preference would be don't go on social media. But even if you put something up and mark it private, that doesn't necessarily keep it private. And insurance companies make a habit now of regularly looking at their adversaries or the client party's social media to see if maybe they catch them doing something that's supposed.
Or maybe they're smiling when they're supposed to be in pain, or they're on a trip, or they're working, or doing the lawn. People have to be very, careful about what they do, because you're going to be asked under oath about it, and you don't want to be put in a position where you're lying. So if you're claiming you're recovering and you're disabled, you want to make sure there's nothing contradict that.
Right, and the safest thing to do is to not.
It's definitely not to post, because it leads to other questions, and the other parties may be able to authorize to look at your email and your social media, even if it's not publicly visible, and it can raise other unnecessary issues or contradict the claim about your pain and suffering.
Yes, you can't be too careful with that.
And you should get advice about your lawyer on either side, about posting things, because it can come back to haunt you.
Again, just can't overemphasize that point.
I guess someone may be out of work or unable to do things for a period of time, depending on the nature of their injuries after an accident, and that's expected. And other people may try to do a little bit more each day if conditions permit.
Right. In the early stages of a case, whether lawsuit's been filed or not, it's important at the very beginning that the lawyer be able to investigate and try to preserve maybe evidence that the client didn't get. But from the client's perspective, it's more important not to be concerned about what the lawyer is going to do, but to be concerned about themselves and to be sure that if they need medical treatment, that they're getting the medical treatment. Again, it goes back to what I was saying about documentation that insurance companies look for.
And you also want to keep the lawyer advised what your doctors are telling you, that you may need surgery, or the fracture may not heal, or this condition could develop, or this consequence could develop, or you can't work in the same way, or you're disabled or on limited duty. Whatever it is that's going on in your world of work, of social activities you can or cannot do, you want to keep your lawyer advised of those so that it's very clear how your life is different after the accident from what it was before the accident.
That's a very important thing. And after the we call it paper discovery is exchanged, the next step is depositions. And that is probably the plaintiff's deposition, the one bringing the lawsuit, is probably the single most important part of the entire litigation other than the trial itself.
And it could be more important because people may be locked into their testimony on both sides. The plaintiffs who are bringing a lawsuit, the defendants who are being sued, they're going to be locked into that deposition testimony. We hear about it in other contexts. And so explain what a deposition is and why that's so important to everyone involved in an accident lawsuit.
The deposition, in New York State, it's called an examination before trial, which can be confusing to people. But a deposition does not involve a judge, does not involve a jury. It's basically can be in a conference room, your lawyer, the other side's lawyer or lawyers, you, and a court reporter or a stenographer. And that's what it is. And you take an oath to tell the truth, and then the lawyers on the other side ask you questions. It's really not your lawyer so much asking questions.
So your claim, your version of the accident and your claim about injuries is going to be carefully scrutinized, almost like cross-examination at a trial.
Actually, what I find a lot of times depositions are for is to set up the cross-examination at the trial. Very often the lawyers are not that antagonistic towards my client. They're trying to just get information so that they can build their case for trial. And we have to meet with the clients to get them prepared to how to answer the questions that they're going to be asked.
Right. No one's going to be antagonistic like, you might see on those courtroom TV series, and your lawyer, such as yourself, is going to protect you from that. But you are entitled to be asked detailed questions about the happening of the accident, the events that took place before, and your medical claims and disability claims from that accident. And if you were another party involved, you'll be asked questions about what you did or did not do around the time of the accident. So everything is going to be an open book. You're going to be detailed questions. No one's going to bully you. Your lawyer's going to protect you, but you'll be asked questions under oath, much like at a trial. And and your lawyer will prepare you, and you may be locked into your testimony. If you at the deposition you say the light was, you don't know what color the light was. At trial, it's going to be hard to say it was green if you were asked earlier and you testified under oath. Or if you don't remember falling, it's going to be hard to change later at the trial if you do remember more details about falling.
Right, but there are important rules that we go over with our clients before depositions, and the biggest ones are don't answer a question that you don't know the answer to, because you don't have to know every answer, and pay attention to the question that you're being asked, and not just say something else.
And you're going to prepare your clients to testify, and the other parties, their lawyers are going to prepare them to testify.
We always have a meeting with the client, because it's not even just what the client says, but it's their demeanor in the way they answer questions. Because I find in the end, a lot of times a case will settle or not settle depending on whether the insurance company thinks my client is going to appear to a jury.
And also how the other witnesses come across, how they testify, their manner, their detail, etc.
Right, but I can't control that.
Oh, I know, but I'm just saying,
right,
if it doesn't go well for them, that will be one factor in evaluating a case down the road. So
yes.
Everyone is going to, that deposition is important for so many reasons. I just want to remind our listeners, we're talking about what to do if you have an accident, and our guest is Ira S. Slavit. He's with the firm of Levine and Slavit, and they have offices in New York and Mineola. And we've been talking about what happens after an accident, the beginning of a lawsuit, and a major part of the lawsuit is this deposition or examination before trial, when people testify under oath about their claims and about the facts of an accident, and it's just so important. And as Ira mentioned, the lawyer will prepare the witness to testify. And any other thoughts you want to mention about this? And just want to remind our listeners, you're listening to Law You Should Know on 90.3 WHPC, the voice of Nassau Community College. And if you missed any portion of the show, the podcast is available at nccradio.org. Ira, anything else you want to mention about depositions, or what kind of discovery, what else goes on, after the deposition, before the case is heard by a judge or jury? Just
one more thing about depositions.
Absolutely.
Which is something that you were talking about a few minutes ago, which is keep your lawyer advised. One thing no lawyer likes is to be surprised by something that their witness says. It could be something they never heard before that's harmful, or more appropriate to what you were saying, maybe there's more medical treatment, and the first time the lawyer's hearing about it is from the client during the deposition, whereas if the lawyer knew about it before, the lawyer would have those records, would know what's in the records, and be able to prepare the witness to answer the questions.
And it could be about a prior accident, too, that all of a sudden, the client may be asked about a deposition, and for some reason they didn't tell you about it.
When I started practicing, it wasn't as easy to find out if somebody had prior claims. Now I don't know how you avoid it. And one thing for sure, if you lose as a party to a lawsuit, if you lose your credibility by giving a blatantly false answer, you're in big trouble, no matter how good your case is otherwise.
And whether you're plaintiff or defendant, credibility is very important. At the deposition, because you're under oath, and at trial, too, because there are consequences for lying or for misstating something or for embellishing something. And, of course, if someone needs an interpreter, they're entitled to an interpreter, whether they're plaintiff or defendant at the deposition.
Yes, and that's actually something that our client shouldn't worry about because the expense of that is borne by the
Exactly,
the party.
but whatever, so they can be heard, so they can understand the question and give appropriate answers. Whether they're plaintiff or defendant, whether they're in court or it's a deposition, they're entitled to an interpreter if they need it.
So you were starting to ask what happens after the
Yeah, we just have a
deposition.
moment or two left. So very briefly.
There's just one more thing, and
Yes,
that's
sure.
where the plaintiff is examined by a doctor or doctors at the insurance company.
And they might
assigns.
testify at trial if there's a controversy over the injuries or their consequence. Ira, what are there any other do's or don'ts to plaintiffs, if they have an accident or bring a lawsuit over an accident?
I just want to emphasize not to give any recorded statements because people think that, like you said, they're professional. The people on the other side are professionals. They're just trying to draw out information, and they'll ask you a question or they'll tell you, oh, this only relates to your car damage. Don't worry. And they'll ask you about how the accident happened, and the next thing you know, your injury claim is in trouble.
And the question or the answer may be slanted, so you got to be very careful.
Right. Again, it's not about somebody not telling the truth. It's not being taken advantage of.
Ira, what is your website where you have information posted about, injury cases and accident cases?
The URL is newyorkinjuries.com. Spell it all out, newyorkinjuries.com. And on the website, we actually have one page, frequently asked questions, and then we have pages related to each of the practice areas that we have information about the attorneys at the office. And, of course, you're always welcome to call because there's no fee for our time. We only collect a fee if we're successful.
And your firm has been representing injured plaintiffs for 90 years?
Louis Levine was my grandfather, my mother's father. So this is a third-generation law firm.
Okay. And anything you want to say about all the ads people hear on TV or in the mass media about some firm somewhere about suing after an accident?
I don't want to say anything disparaging about anyone else, but I think you just need to be careful that you select a lawyer who cares about you in your case. You're not just going to a place where you're just in a mill or a number.
And also who's been around in New York for a long period of time.
Yes.
Okay, I'd like to thank our guest, Ira S. Slavit, for being a guest on Law You Should Know and talking to us about what to do if you have an accident, if you missed any portion of the program, or you want to tell someone else about it. The podcast is at nccradio.org. Please remember, whatever you've heard is for information only. And please join us next week at this same time for another program on Law You Should Know on 90.3 on WHPC, the voice of Nassau Community College in Garden City, New York.